participated in encouraging those individuals to commit perjury?
I believe that your office...
I didn't say my office. I said me.
Your office is the law firm. You're representing the city through that law firm.
Sir, my question is, as to myself, Robert Rush, I want to know, what is the basis for you saying that I encouraged Mayor Calderwood to commit perjury, Mr. Watson to commit perjury, or anyone else?
If you go back in the record, you'll hear what I just said. I said, I witnessed Gene Calderwood commit perjury. I witnessed Clovis Watson commit perjury, and I witnessed Alan Henderson commit perjury. You just asked me before that which things that I consider appearing to be perjured statements that you participated in bringing. And I said, that document that you have right there, that you brought after the fact, knowing that it was not produced before, appears to me you're bringing into evidence perjured statements. And I told you the other two times where I believe the other time when all of a sudden those provisional ballots were produced. I don't know whether you knew about those or not, but you certainly should have seen the problematic nature of that at that time, and yet you tried to explain that away. I don't think really is the job of a lawyer to explain away facts.
What about trying to explain away?
The provisional ballots. You tried to explain away the provisional ballots.
You mean through provisional evidence?
Yeah. Through manufacturing evidence. Those ballots were produced open. And then it was said, but look, 2 are for Irby, 2 are for Lewis, therefore it nullified it. Well, you shouldn't have known whether 2 were for Lewis or Irby. Nobody should have. Nobody had a right to look in those ballots. In fact, the secrecy of those voters' votes was denied by Alan Henderson in opening those, because he knew exactly who voted for whom.
How was that the manufacturing of evidence?
You're presenting as your legal defense that these 4 provisional ballots, even though they weren't counted, shouldn't be considered to be 4 problematic ballots because they wash out in the end, because we know that 2 are for Lewis and 2 are for Irby. Well, you can only know that if you open those. And those were not opened during the canvassing process. They were only opened after we introduced into evidence the existence of those 4, and you have used that unlawfully obtained evidence as evidence to support, and it's not documentable.
How is that the manufacturing of evidence is my question.
You're trying to say that we know for a fact that these ballots were 2 for Lewis and 2 for Irby.
Were they not in fact 2 for Lewis
and
2 for Irby?
We have no idea what the original 4 provisional ballots were. You produced 4 ballots that you claim were for Lewis and for Irby.
Oh, so I understand. Your claim is that those 4 ballots were manufactured evidence? That's what you're saying?
The opening of 4 ballots and presenting them as if that was what was inside those envelopes, I believe is the manufacturing of evidence, yes. Because nobody saw those ballots opened. They weren't opened according to the law. They weren't opened in public. They weren't opened by the canvassing board. This was done behind the scenes, whether it was with the explicit or implicit participation of you or your office, I have no idea. But you have presented it as if it were a known fact that these 4 ballots are 2 for Irby and 2 for Lewis. And I find that to be ethically problematic.
As to the encouragement of perjury on my office or myself regarding the sworn testimony of any witness in this case, what is the basis for that statement?
As I stated, for example, Willette Dixon stated that for some unexplained reason, and certainly with no one's knowledge as far as I know, and without, as far as I know, the city commission and city manager never instructed your office to do this formally. But your sister had an interview with Willette Dixon to discuss matters relating to this case. I don't know what she said.
How many you interviewed Willette Dixon?
I personally did. Mr. Little didn't.
How many times did you?
I interviewed her once, and then I spoke to her about 3 times after that, on a personal level. But I interviewed her at her own volition. I still want to know why your sister had a meeting with her to discuss this issue outside of this legal, after the case was filed, when your firm is representing the city in this case.
And you find that there's something problematic about that?
Yeah. Especially since you're the city attorney, and everything you should do is supposed to be public. When you're doing things that aren't for particular litigation matters. non-financial sector firm, I believe, is supposed to be trying litigation matters, not just assume that you're the litigator for the city.
Do you think it's improper to interview potential witnesses in a case?
I think the proper way of the lawyers doing that is through depositions, isn't it? But I mean, I
no,
would
it's not
like
Mr. Grapski.
Well, I
want to take statements from witnesses all the time.
Okay.
Investigators take statements from witnesses all the time. Try to talk to a witness before I take their deposition, unless they're represented by counsel and there's a party. In every single case.
The only thing I know is that Willette Dixon said to me, without any coercion, without even my asking her, she just volunteered to me a whole story about how she, and she went in detail, and she told this story 3 or 4 times, and she told it to me more than once, and she told it to about 10 people.
And this was in the presence of the person who was employing her in pain.
No. First of all, Shauna Duran wasn't present there, and so just because you were doing it at her office, I don't think that constitutes in the presence of her employer. I think that's another little unethical attempt on your part to sort of twist the facts. Willette Dixon, without any coercion, said to me that Clovis Watson approached her when she had no intention of voting to vote. Told her who to vote for.
That's not a question.
You asked me.
This isn't for you to sit here and just rant.
You asked me the question. This is my answer.
Those are all the questions.
Thank you.
Was there anything about the absentee ballot law that...
Ooh, that's true. The absentee ballot law is perjured, is false statements. They constitute perjury. The absentee ballot law was destroyed. We know that for a fact. We know that Alan Henderson testified that it was destroyed. It was assimilated back into earth. On the weekend between my first requesting it and my arrest on the following Monday, Clovis Watson wrote a memorandum to the city saying it was destroyed. Yet you allowed Alan Henderson to put into evidence another document which has nothing to do with that, and you purported to make that out to be the absentee ballot law.
Are you referring to the document that Mr. Henderson referred to as the compilation of all of his notes?
No, it's the document that he printed off of a spreadsheet on his computer, which is not a compilation of all of his notes. And it's a document that we already had possession of prior to him giving it under that request, because it was a completely different document. In fact, we have 2 versions of that document. That's a 3rd version, which doesn't even correspond to the first 2. And I've actually done the research. I've gone and figured out how he was able to add information to it and where he got it from. And we know it conflicts with the actual facts. But you put it together as if it was a...
How did you add information?
Oh, by the way, are you supposed to be asking me a question?
Well, we're...
Okay.
That was redirect.
Okay, I don't mind. How do I know what?
How do you know that you added evidence?
Because I have the document that existed prior to that. I have that spreadsheet printed out on April 11th, and I have that spreadsheet printed out on April 7th, I believe. And then this spreadsheet was printed out in September or October. And added to it are 2 columns that didn't exist prior. And in those, in and out. Now, those 2 columns do not constitute what the absentee ballot law required.
What's the purpose of the in and out column?
Well, the in and out column was added because it was trying to make it look more like what the statute required. It didn't sufficiently cover it, but
what did the in and out column constitute?
It constitutes 2 dates. It said this is when apparently, it's when, that's what it seems to allege, that on the in column and the out column was when the ballot was given out, and the in column was when it was received. However, we know that the dates in that do not come from the actual dates that the ballots were received or cast.
Where did they come from?
Alan Henderson.
Well, where did Alan Henderson come from?
Well, for example, I can give you a good example. Willette Dixon. Here's another example of Alan Henderson perjuring himself. Alan Henderson testified that he wrote the date, April 7th, on Willette Dixon's ballot envelope. Willette Dixon testified, and we know for a fact, she cast her vote on April 10th.
How do you know that?
She testified to it. Oh, she testified to it.
Respectfully, that is not what she testified.
Oh, you want to pull out the deposition?